You can also ask him about yung the Dicini case.
Sige. Okay, Westinghouse.
Yep.
Sige.
Prosecutor of the International Criminal Court is seeking a full investigation into the country's war on drugs. The ICC's preliminary investigation found there was basis to believe that the crime against humanity of murder was committed in the country. Former UN Special Rapporteur Agnes Calamard says the ICC's request to investigate killings in the Philippines marks a moment of hope for the victims' families.
Nakikiusap ako sa mga human rights. Kindly take a deeper look into the drug situation. You would notice that there are really persons who die almost daily because ito lumaban talaga at hindi kasali ang pulis ko na may tama at namatay rin.
Malacanang maintains that President Duterte will never cooperate in the potential drug war probe of the International Criminal Court or ICC.
It is legally erroneous because in the first place, the ICC has no jurisdiction over the subject matter. Secondly, the case, even for purposes of formal investigation, is barred by the principle of complementarity. And thirdly, the investigation is not pursuant or in aid of substantial justice.
The International Criminal Court says there is reasonable basis to believe that the Duterte government committed crimes against humanity of murder into the extrajudicial killings in its war on drugs. Will a full investigation bring justice to thousands who were killed in the war on drugs? We discuss in this episode of The Chiefs. Welcome to this special edition of The Chiefs. I'm Robbie Alampay, and with me online are Ami Pamintuan of the Philippine Star and Ed Lingao of One News. Chiefs, good evening.
Hi.
Good evening.
Now,
Happy
let's
Tuesday.
go straight to our first guest, because this guest of ours was, I was interviewing him just a few minutes ago on the big story, obviously on the big story for this evening, the ICC's request for a full investigation on the war on drugs. Let's welcome Center Law's Attorney Gilbert Andres. Attorney Andres, welcome again.
Hi, sir. Good evening.
Nakamute pa po yata kayo.
Good evening to the Chiefs.
Okay, so let's start with the two basic things that government is saying. First, that we are not under the jurisdiction of the ICC, and second, that even if we were, we're not going to cooperate anyway. What is there to say on the first point, and what can be done on the second point?
Okay, on the first point, it's inaccurate. It's not precise. Why? Even though we withdrew from the ICC and it took place, yung effect of the withdrawal on March of 17, 2019, there was still a time that we were a state party to the ICC. And that was from November 1, 2011 to March 16, 2019. Therefore, any international crimes that occurred in Philippine territory during that period is within the jurisdiction of the ICC.
And on the second point, if they refuse to cooperate, what options does the ICC or anybody advocating for an investigation actually have?
Well, on the second point, I have two answers. First is that the Philippines, even though it withdrew, it still has that obligation actually to cooperate with the ICC. And that's actually the residual obligation of the Philippines under Article 127, Paragraph 2 of the Rome Statute. But in the unfortunate event that the Philippine administration refuses to cooperate, then I think the ICC Office of the Prosecutor still has creative means to resort to so that it can have a good investigation as to the international crimes committed within the Philippines.
Attorney, on the other
Attorney Gilbert,
this
go ahead,
is
Ami.
this is a request pa lang, of the prosecutor of the ICC to investigate. She will need the approval of a larger group, and it will take, that decision can be issued within 120 days. And there will be a new prosecutor taking over next week. Unang-una, can the new prosecutor overturn that recommendation? At pangalawa, is there a possibility, malaki ba yung possibility that the larger body will deny the recommendation? What are the chances of rejection by the larger body? Kasi this is just a request pa lang at this point.
On the first question, Ami, I think the next prosecutor, Prosecutor Tan, will most probably not withdraw that request for investigation. Why? There's already that momentum, not only of the facts that are presented, but also the analysis of the facts as seen in the report of the OTP. So I think it's really, it has a low probability that he will withdraw that application for an investigation. Number two, the pretrial chamber, yes, it may or may not approve. But I think that it will approve based on the facts presented and the pieces of sources, numerous sources cited in the report, that indeed there are really instances of crimes against humanity in the Philippines during the time when we were a state party.
Attorney Gilbert, there are some people who cite the case of Afghanistan. I think it was in 2019, when the prosecutor also asked for authority to investigate. And in that particular case, I think the pretrial chamber rejected the petition on the argument that they did not see Afghanistan cooperating in any way in an investigation, and that would render any attempt to investigate moot and academic, although that was later overturned, if I remember correctly. Pero there is that possibility that it could be overturned, if only because of the fact na hindi cooperative yung subject ng investigation.
So in fact, the controlling case in the Afghanistan situation is really the appeals chamber decision. Na it's still, the appeals chamber overturned the pretrial chamber, so it actually authorized the investigation. In fact, the very significant example here, the very significant case law here, is actually the Burundi case. Because in fact, in Burundi actually withdrew from the ICC, but the pretrial chamber still authorized the investigation upon Burundi, although the authorization was before the withdrawal. Also,
Yes, sir.
in fact,
Well, sir, I brought up Afghanistan kasi with that argument, at least the first argument in rejecting the Afghanistan proposal or petition was the possibility of non-cooperation by the subject of the investigation. So it turns out that could be an important variable in making the decision. Although it was not a final variable, but it could be a variable. In this case, kasi we're seeing non-cooperation. There's already a promise of non-cooperation from the part of the Philippine government.
I think I recognize the insight that you're trying to push, Ed. The administration might be laying the groundwork to invoke that pretrial chamber decision on the Afghanistan situation, although that was overturned by the appeals chamber.
Attorney, how long does it take anyway? I mean, the next part of this process, getting that request approved, and then eventually, how long does it reasonably take before we actually see any attempts by the ICC or a request from the ICC to the Philippines to come and investigate?
Well, I think it's really difficult to say, how long will it take, But suffice it to say that the pretrial chamber will really look at whether or not there is first rationale, materiae, meaning to say is there jurisdiction over these alleged crimes. So yun muna yung unang tanong. And the allegation here is crimes against humanity. So based on this report, is there crimes against humanity, specifically murder? Second is rationale tempore, so it will have to determine whether or not it was committed within the time period when the Philippines was still a state party. So if the ICC pretrial chamber will be fast about it, it should be within months. But if they really want to see the sources behind the facts, then it will take a year.
I ask precisely because if it takes a year, that takes us to the next elections. And we're
Yes.
speculating about the options and the instincts and the reflex of the Duterte administration. But there's a real possibility here that this is going to be a matter that this is a bridge that will be crossed by the next administration. Is that correct?
Yes, Robbie. In fact, I think you are actually trying to relate it with the cooperation of the next administration. So the non-cooperation of this present administration will be moot and academic if there's a new administration with a different philosophical dispensation.
Yes, but not only as a matter of that. I also ask because of the whole argument about capability and willingness to undergo and to carry out our own investigation here in the Philippines, to let our own justice system work. If we get to another administration, and even assuming that it's not a Duterte ally, let's say it's somebody more open to wanting to find out what happens, doesn't that administration presumably start from a clean slate with its own burden to try to prove to everyone that no, our justice system will work under this particularly new administration, and doesn't therefore put it in, ironically, in the same footing as the Duterte administration that is saying that we don't need an international investigation because we can make our justice system work?
Okay. What you're trying to paint as a hypothetical situation is the next administration really doing an honest-to-goodness investigation.
Yes, because
So that there will be accountability.
I find it ironic and awkward if the next administration starts off on the premise that even under this new dispensation, the justice system, we presume, will not work.
In fact, that's a distinct possibility because, in fact, in our presidential histories, there are actually prosecution of ex-incumbent presidents. So, in fact, that's a possibility. And if the next administration really wants an honest-to-goodness investigation and prosecution, then it can actually invoke our own IHL Act, RA 9851. Wherein there is also the crime against humanity, the same crime against humanity that's in Article 7 of the Rome Statute. So that's really a distinct possibility. And the irony of that is the president, if he is indicted, can actually use it to actually question
The
the
next
administration
administration.
of the case
That's right.
before the ICC.
That's the argument of the government now. Actually, that the ICC cannot have jurisdiction over matters like this because our justice system is working right now. In fact, I think that's what critics are saying. That's what they are saying in this ongoing investigation by the DOJ, by the conviction of certain police officers for previous EJK cases. So that is what they're saying, and in fact, that's what the DFA is also saying, that they are protesting, they are saying this is going to be a disincentive for other countries to join the ICC because they are saying an overreach, something to that effect that the ICC might be overreaching if it decides to have jurisdiction over a state where the justice system is still working. So is that actually a possibility that the chamber will deny based on this argument that the justice system is working in the Philippines?
Well, technically, as of this point, the pretrial chamber will not actually consider admissibility because, in fact, it will be considered during the trial stage. In fact, during the trial stage, the state party itself, in this case, the Philippines, even though it's now a former state party, can actually argue that it is actually investigating these instances of crimes against humanity. So, which leads me to my second point. The question really that we have to ask here in the Philippines is that in the first place, is there an investigation on these instances of crimes against humanity? Because if we look at his history, if we look at the news reports and the press releases of this administration, they're just saying, Kian de los Santos, there was a prosecution. In fact, there was even a conviction. But the question is it for crimes against humanity? Because if it's not for crimes against humanity, if it's not for all the 5,000 recognized admitted deaths under police operations, then it's not investigating. And if it's not investigating, then the situation in the Philippines is admissible before the ICC.
What about the Department of Justice and the Secretary of Justice going to the United Nations and acknowledging that beyond Kian de los Santos, we have audited the reports. We acknowledge that more than half of the police reports of the tens of thousands reports filed on EJ case, more than half we found really irregular. There is reason to investigate the police because we found more than half of the reports anomalous and irregular. Doesn't that raise the level of argument of government that we're taking a hard look at this beyond the one case of Kian de los Santos?
I don't think it bolsters the position of this administration because in the first place, if the DOJ will really recommend investigations and prosecution, then there should have been informations filed in regional trial courts all over the Philippines. But there is none as of now. So that's not the kind of investigation that will actually bar the admissibility of the situation before the ICC. So the issue, the prime question, has there been informations filed in court, not just against one police officer, against two police officers, but against the chain of command, against whoever tried to carry out, who ordered and carried out this policy of extrajudicial killings?
Attorney, we're almost out of time for this particular segment, but I did want to ask you, because you are representing Center Law, this request for investigation does not just cover the war on drugs from 2016. It actually goes all the way back to 2011, and it covers, for that matter, alleged extrajudicial killings in the province and the city of Davao. When President Duterte was then mayor of Davao, this goes back to the original meaning of DDS, the Davao Death Squads. There was a Justice Department investigation into that. I want to ask you in particular about the involvement of Center Law there, and in particular, Attorney Harry Roque, who is now spokesman for President Duterte, but I was a very, very active lawyer then for Center Law. I'm just wondering, in that part of Attorney Roque's history, what was his position, what was his hypothesis and theory, and what was his stand with regards to DDS in Davao during that time?
I think it's a matter of record that Center Law and Attorney Harry Roque even went to Davao City. I think that's sometime January of 2007 or 2006, if I'm not mistaken. And in fact, was Center Law together with then CHR Chair De Lima. And the specific visit there in Davao City was actually to investigate allegations, instances of extrajudicial killings committed by the DDS. And in fact, they made attempts to investigate, although the local atmosphere at the time was not conducive. Hence, there was really no forensic investigation that was done, although they really made that strong statement against EJ case
But he
by
was
the DDS.
yeah, but he was executive director then. Assuming you cannot extricate, the position of center law from Harry Roque as executive director back then. I'm just curious, what was the takeaway? What was the stand? What was the findings, as most formal as it can get, of center law from those fact-finding missions?
Secretary Roque was then the chairperson of Center Law. Well, I think it's also a matter of record that Center Law's position is that it's against EJ case committed by whoever and whichever public officer. So, in fact, that's the reason why that during the Maguindanao massacre, Center Law together with the CHR did a parallel investigation because our strong position has always been consistent. We are against EJ case, whether perpetrated
No, but not on
under...
EJ cases per se, but particularly on the fact-finding to Davao. What was, I presume there was some kind of a report. I presume there were some recommendations there. I mean, what were the, like I said, the formal recommendations of Harry Roque as chairperson of Center Law emerging from those fact-finding missions to Davao?
Well, I really cannot quote the exact words, but it was really a condemnation of the vigilante-style killings being perpetuated in Davao City. Because in fact, it's when you go to Davao, even during that time, it's actually common knowledge that there have been vigilante-style killings committed by the DDS. So there was a strong condemnation of vigilante-style killings.
Okay. Attorney Gilbert Andres of Center Law, maraming salamat po.
Maraming salamat po. Mabuhay tayo.
And we will continue this conversation on this topic. Please stay with us. We just need to take a break. The Chiefs will be right back. Welcome back. The Chiefs now joining us is Attorney Ruben Carranza of the International Center for Transitional Justice. Good evening from the Philippines, Attorney Carranza.
Good evening.
Of course, we say good evening because it's good morning in New York where Attorney Carranza is. Attorney, kanina sinabi ni Attorney Andres that if the government ultimately refuses to cooperate, the ICC still has the option to be creative in its investigations. What might that mean? What are some creative options that the ICC might have in its arsenal to carry out an investigation in a country, in a jurisdiction where the authorities will not cooperate?
Well, a good example would be the fact that in the request that was filed by the prosecutor for authority to open an investigation, she already indicated that the prosecutor's office has already began to preserve evidence and to protect witnesses, even prior to this request for authorization. So there have already been steps taken to preserve evidence, protect witnesses, because that doesn't even require creativity. That's in the Rome Statute itself. But more importantly, we are already the internet has been in existence for decades. Part of the detailed discussion in the request was taken from publicly available sources as well as sources forwarded to the prosecutor by various groups, including groups in the Philippines and outside the Philippines. There are also situations, some of them in the ICC, but many outside the ICC, where commissions of inquiry, investigators from the UN brought witnesses, specific individuals outside the country where they were located. An example is Sri Lanka and the UN Commission of Inquiry on Sri Lanka, where they conducted their interviews outside Sri Lanka by securing the witnesses from that country to go outside. So there are various ways this can be done, and so it's not impossible to actually pursue an investigation even if the Philippine government right now refuses to cooperate.
Speaking of the internet, speaking of sorry, quickly lang. Speaking of the internet, you talked about preserving evidence and so on. But speaking of internet, like this, pwede tayo mag-Zoom. Zoom will count to depose witnesses from here.
Well, not necessarily Zoom, but the ICC has already done in camera, in chambers, as well as remote proceedings, recently. So it's neither impossible nor disallowed. What might be problematic are physical evidence, including, for example, bodies that may have to be exhumed, bullet casings that have to be examined. Now, those physical evidence items, however, would have corresponding reports, and that's where it becomes either difficult and perhaps the reason why Rodrigo Duterte's government has refused to open up police reports involving specific examples of killings.
Yes, sir. Well, sir, yun nga, kasi we talked to a lot of lawyers who've said na forensic evidence will always trump testimonial evidence. Well, simply because it's data-based versus, memory-based. With that in mind, how strong what kind of evidence could the ICC get from the Philippines that could be strong enough to build a case of crimes against humanity, especially if there's no cooperation? What kind of forensic evidence could possibly be gotten by the ICC?
There are already statements from family members, neighbors, friends, witnesses who saw and heard actual killings take place the way they saw it and inconsistent with police reports. And these are detailed in the prosecutor's request. So there are also parts of the request that the version that is publicly available, at least, that have been redacted. And I assume that these redacted parts contain even more detail, but have to be redacted to protect the identity and locations of those who provided the detail. So, in other words, while forensic physical evidence is important, eyewitness statements are just as important. But even beyond those two types of evidence that may be used in any criminal trial, there is an important part of the ICC's case that has to be taken into account, which is the gap between the direct perpetrators, those who actually commit the killings, and the indirect co-perpetrators, those who order or enable the killings. Now, that gap is one of the most important gaps that require evidence, require analysis, but ultimately may be addressed by some of the statements of the President of the Philippines that are already referred to in the request.
Well, that's
Yes,
what
sir. I can imagine what you're referring to, all the statements made publicly by the President. But at the same time, the President and Malacanang has always used the backup that never take the President literally. I don't know how that counts in this particular case. When you look at making the case between SPO1 and Commander-in-Chief? How concrete does that have to be?
Well, two things. First, he's the president, he's head of state, and international law applies to the ICC just as it applies to the UN Convention on the Law of the Sea arbitration proceedings. Statements of heads of state are actually have legal weight in international law. You can discount them by claiming that they were joking or that they don't even have to be coherent statements. They don't even have to be complete sentences. They don't even have to be uttered in logical ways, but they are going to have a legal effect in proceedings before the ICC.
But on the other hand, he keeps qualifying his statements, right? And that's the defense of the administration. That there is no, it's a crimes against humanity. There is no state policy and there is no systematic movement to carry out EJKs. That's what they're saying. So if the president says, oh, patayin niyo yan, patayin niyo yan, and then later he says, ang sinasabi ko lang naman papatayin niyo kapag pag lumaban and self-defense. That's what he keeps saying. So, paano yun? And there's no written order, although there was a rumor at the start of the administration that there was actually a written order. Of course, I doubt if that will ever surface. Pero paano yun kapag ganun?
Well, there are a couple of considerations here that might be helpful. The ICC in some cases relies on what have been called insider witnesses. People who actually were involved in the commission of the crime to an extent that they can testify about not just their participation in the crime, but the connection to higher officials in the commission of the crime. So insider witnesses are important, and we have reason to believe that there are insider witnesses that are available to the court. The president's statements, he can qualify, like I said, he can even deny, but denials and qualifications do not take away the fact that he made these statements. Now, the important fact here is to consider the consequences of the statements. If nothing happened after he orders people to kill, after he encourages policemen to execute, after he tells people to arm themselves and commit extrajudicial killings, then there's no consequence. There's no crime. Incitement to crimes against humanity is in fact not a crime under the Rome Statute. But incitement that leads to killings, the crime isn't the incitement. The crime is the killing, and therefore these statements contributed to that and may constitute indirect co-perpetration by those who make those statements.
Attorney Carranza, I want to talk about the ICC also, in particular the prosecutors. What can you tell us about Karim Khan?
Well, he emerged as the prosecutor after a particularly complex and even politically fraught process of selection. There were other nominees, including an Irish nominee that some non-government organizations supported. There were questions around Karim Khan's earlier role as a defense lawyer for example, the former president. In the case of the former president in the case of the president of Kenya, not former. At the same time, he also comes from a background of having been involved in global South cases, whether as a defense lawyer or as an investigator. So I think that's important. Most importantly for Filipinos, he has been to the Philippines. He has had some familiarity with the experiences of families of those killed in the drug war. And he's the prosecutor. He's not a judge. So a prosecutor who knows the pain of families whose family members were executed by police and by death squads will play an important role in prosecuting these cases.
Now, on the other side of it is the woman he replaces, Fatou Bensouda, and reading her probably her final act here, not just requesting for the investigation, but also a message there for the ICC, where basically she's saying, if I'm reading it right, hey, we need help. we need resources, we need support, and so on. What was she saying, and what does it say about the pragmatic realities of the ICC in cases like this?
So this brings up the matter of managing expectations. It's very easy to oversimplify these developments at the ICC. It's very easy to make sentences that say certain Philippine officials will soon be in jail, or certain officials and government leaders will soon face justice. But that's not really, I think, how we should frame this and how we should look at what is happening at the ICC. You're right, Roby. The ICC prosecutor in her press statement does refer to the fact that the ICC needs resources to carry out its investigations and to proceed with its prosecutions, with the trials. That said, that lack of resources also, I think, emerges from the fact that the prosecutor, the outgoing one, Fatou Bensouda, opened up examinations and now investigations and trials of cases and situations involving countries that had long evaded the ICC's attention: Afghanistan and the United States, Israel, Palestine. So you have a prosecutor that, in my opinion, actually has tried to do what many of us in the global South want her to do, want the ICC to do. And so the role of the Assembly of States Parties, that's the group that oversees the ICC, as well as the incoming prosecutor, is to find and use the resources that they can find to proceed with these cases rather than to step back because they don't have the resources. The problem is you need resources. The solution is to provide them and to find them.
Attorney, if the subject of an ICC investigation dies, can the investigation proceed?
No, because that means there can be no prosecution of a dead person. But
just for truth finding.
well, yes and no. I'll give you a good example of the inadequacy of criminal proceedings as a form of justice. There is an international tribunal in Cambodia to prosecute former Khmer Rouge leaders, and it's been in existence for over a decade. But Khmer Rouge leaders, by the time they were prosecuted, are old, and many of them died. So many of them, the prosecutions had to be dismissed, and only a handful have actually been convicted and tried. Some Cambodians, families of victims of the Khmer Rouge and the overall larger war that involved the United States, have in fact pointed out that they would be fine with trials of dead persons. Right? So your point about truth-seeking is, in fact, partly what I work on in my role as senior expert at the International Center for Transitional Justice.
Yeah, just for closure. And yes, transitional justice. So it's possible.
Well, it's another example in Mexico, where, as we know, there is a real drug war, not a concocted one between civilians being killed by death squads. The president of Mexico, in fact, created a truth commission to examine the consequences of the drug war, while at the same time still trying to continue a drug policy and a criminal justice policy side by side with the truth-seeking process.
Okay.
Ernie, I hope you don't mind. I'd like to shift gears very quickly. You used to be commissioner of the Presidential Commission on Good Government. Now, just today, the Supreme Court of the Philippines awarded the Philippine government 1.1 billion, more than a billion pesos in damages versus Herminio Dicini in connection with the BNPP, the Bataan Nuclear Power Plant case. I'm trying to imagine how Dicini's estate could still have 1 billion pesos available to pay out. When you were in the PCGG, what numbers were you looking at?
Well, first of all, the Bataan Nuclear Power Plant cost 2 billion. So what he's being asked to pay, what his estate's being asked to pay, is only half of what ultimately they pocketed, including the American companies that paid bribes to his family and to the Marcos family. But Dicini fled to Europe when the Marcos dictatorship fell, and in Europe he was involved in several attempts at hiding ill-gotten wealth, presumably both his as well as the Marcos family's wealth. And Dicini even somehow used his ill-gotten wealth to obtain a royal title, a Count Herminio Dicini type title in Austria. So his family would have assets outside the country, and some of those assets were frozen when I was in the PCGG.
Well, may have to be a subject for another episode of the BNPP, PCGG in general. In the meantime, Attorney Carranza, we appreciate your insights, but we'll have to move on because we have somebody from the armed forces next up. Maraming salamat po, Attorney Carranza.
Thank you.
Thank you, sir.
And now
And
with
good
us
morning.
is Brigadier General Joel Alejandro Naknak, Chief of the AFP Human Rights Office. Good evening, General Naknak.
Good evening. Good evening to everyone.
Good evening, sir.
General, we'll start by giving you, the floor to respond to this request by the prosecutor of the ICC to investigate the killings during the war on drugs from actually even predating the war on drugs, but looking into EJ case and killings from 2011 to 2019. Your response, sir, on behalf of the AFP and for that matter for our state forces.
Well, for the AFP, I guess for the ICC to be functional, it should be recognized that the ICC to be trying a case, the state should be unwilling to participate in the prosecution of the case and unable to prosecute the same. But for as long as I know, the Philippines is has a justice system that is functioning, and our government is able to and willing to try cases. In fact, the AO35 mechanism is functioning under the DOJ, which has been established way back even the time of our former president.
Attorney, there's lilipat ako dun sa Masbate, no? What happened there, yung namatay yung the Absalons. I want to know the extent of the use of landmines by armed threats to the government. How extensive is it, and which groups are using it? We know that, well, there have been other previous reports of the NPA using this, but which other groups are using landmines, whether improvised or original or whatever? How extensive is it?
Yes, thank you, Madam Ami, for that question. Actually, we have submitted reports actually to the Commission on Human Rights and also to the ICRC and to the UN and to other government agencies about international human rights violations or international humanitarian law violations committed by the communist terrorist group. And it totaled for the past 10 years, from 2010 to 2020, about 1,506, among which is 141 cases of the use, transport, manufacture, and stockpiling of anti-personnel mines, which cost the lives of several Filipinos. In fact, there are 5 civilians killed, and this is not including the Masbate incident because our records speaks only from 2010 to 2020. And of course, we have not submitted yet the cases which were caused by the Abu Sayyaf groups and other lawless elements in the south.
So this includes original landmines. You're saying they include original landmines. I want to know, kasi where are they getting this?
Where are they getting the landmines? These are some what we call the improvised devices, which is actually also banned by international law. If we recall, in 1980, we have the UN Convention on Certain Weapons, which the different signatories of the UN Convention agreed to limit the effects of certain weapons to include landmines and other devices. And in Protocol 2 of 1996, it really clarified that anti-personnel mines are banned, supposed to be banned. And it was in the Ottawa Treaty of 1997 that the convention was made to be known to be prohibiting said application or use of anti-personnel mines. Not only the use, but even the transport, manufacture, and stockpiling of said mines. And to add it up, we have the Oslo Diplomatic Conference, which adopted the same Ottawa Treaty for the total ban of anti-personnel mines, which unfortunately, one of our fellow Filipinos right now in Masbate suffered, or two of them died because of this, the employment of anti-personnel mines by the CTGs or the communist terrorist groups.
Well, General, talaga namang condemnable po yung paggamit ng mines, especially against civilians. Pero siguro po, well, just to be clear po, I think the Ottawa Treaty and the UN conventions actually ban yung natawag na victim-activated anti-personnel mines. I don't recall them banning what you would call yung command-detonated mines. When we say victim-activated, this refers to, and I'll quote out Ottawa Treaty, mines that are activated by proximity, presence, and contact with the victim. In other words, kumbaga kung natapakan o natisod lamang, versus yung pinasabog dahil may control yung gumagamit.
Well, ganito po yan. I would like to explain it deeper. Totoo pong the different conventions have allowed several types of mines, provided that the area to be used for the laying of these mines are well marked. There is a use of sentinel, meaning may bantay, and it's possible also to place fences over these areas, so that the civilians that passes through these areas will not be hit by these landmines, if ever the civilians will be using such route. And unfortunately, in the case of the Philippines, most of the landmines being used, whether anti-personnel, whether tank mines used by the Communist Party, are placed or laid along civilian routes. That's why they are really in violation of international laws, as well as RA 9851, which localizes our IHL.
In the meantime, General, balikan natin yung kaso mismo, yung the death of Absalon. CPP, NPAs, they say they've taken responsibility for it, but they have refused to turn over the people suspected of carrying out the killings and the attack. What should accountability look like? What should be a valid manifestation of accountability in your view, and how do we get there?
Well, if anybody in the Philippines and even outside the Philippines, everybody who commits a crime and the court has jurisdiction over them, therefore they should be made accountable over these institutional bodies such as the courts in our land, the municipal trial courts. In other words, in our judicial system, they should be made accountable. Ganun po yung sistema dapat na masunod. If there is no such accountability that can be used or traced back to them, then how can justice be attained?
Ano na po yung
In this particular case, General, has the AFP been able to identify in specifics yung the people involved, the rebels involved dun sa Masbate incident? Hindi lang po Jando, kumbaga, yung talagang mga pangalan.
According to the Southern Luzon Command, sir, the identities were noted. I don't have the names of those people in charge, but during the follow-up operations made by 9th Infantry Division in that area, there were 3 NPAs who were killed, and several, about more than 16 high-powered firearms were recovered near the incident area.
Meron ding report that after the blast, there were gunshots, no? The crew were shot down, the Absalons. Can you give us more details about this?
As I've heard it, ma'am, after the incident of the blasts, though the perpetrators, the NPAs, went near the Absalon cousins, and they shot them in the head and several in their respective in the bodies, or so they suffered gunshot wounds as well. This was witnessed by the other relatives and friends of Keith and Nolven, who were in the vicinity, because this is a cycling group. Nagbisikleta lang sila papunta sa isang barangay, and the other party, about 4 of them, was behind, and they were able to hide to witness the incident of the blast, as well as the firing of the NPAs into these people.
So the implication is that the cousins were actually targeted. Yung ba yung implication nun? Na it was not a random accident na, uy, nadaanan pala nila yung landmine. They were targeted kung binaril pa sila.
Precisely, they were targeted, but maybe I cannot conclude whether they were really the targets, but of course with that incident, it's clear that there is indiscriminate use of landmines. And this is not the only case we have recorded in the Philippines. Even before, even during my lieutenant days, there were a lot of landmining incidents in Kalinga, Payao, and in other parts of the Philippines. And from 2010 to 2020, as I've said, there are already 141 incidents that contributed to the casualties, about 224 casualties already because of this.
Sir, as a matter of policy, sir, well, you are the head of the AFP's Human Rights Office. As a matter of policy, sir, the AFP no longer uses landmines. Is that correct? Yung dating mga Claymore mines, hindi na po ginagamit ngayon, at yung mga pang-perimeter defense?
Correct, Ed. We have already complied with the different treaties, as I mentioned a while ago.
Okay.
Pero may demining operations ba ang AFP? How was the incident in Masbate affected your counter-insurgency operations, for example? Nag-intensify ba, at least in Masbate?
Yes, Madam Ami. The incident in Masbate triggered some operations conducted by the PNP as well as the AFP, which resulted, as I mentioned, the recovery of about 16 high-powered firearms and the killing of 3 NPAs.
Now, on the other side of the intensified campaign, what does this all mean for peace talks? Well, not for the peace talks. I mean, because it's been formally ended since 2017. Pero what is the implications on the feasibility or sa mismong usapin ng peace talks?
As we have right now, we have what we call the localized peace talks. There is no national level peace talks, but we have the localized peace talks, and the result of which is evident by the series of surrenders by the NPAs in various areas of the Philippines, various regions and provinces. As we have recorded, there are about more than 3,000 of surrenders for the past several years already. Not only from the armed group, as well as the support groups of the NPAs.
But General, give us an idea of ano ba ibig sabihin nun? No? Pagka sinabi natin, walang peace talks, pero merong localized peace talks, what is actually going on the ground? Ano yung mga halimbawa niyan to give us an idea of what's actually taking place?
There is what we call now the National Task Force to End the Local Insurgency, or the Local Armed Communist Insurgency, and we have the regional task groups or task forces as well, which concentrates on the local side, regional part. And the commanders on the ground, both PNP, AFP, as well as the local government units, has gathered together for a whole of nation, full of government approach to convince those people who are still in the armed rebel group to join the mainstream of society. And we have this program. The firearms will be compensated, and there are also some livelihood packages that are offered for them to go back to the mainstream of society. And this has been so effective for the past several years.
Okay.
Meron din bang demining operations ang AFP? Because you mentioned a lot of landmines, ah. Ano yung itsura ng demining ninyo? Meron bang ganon?
For the demining activity, as there are operations conducted by the AFP in various areas of the country, as we recover the mines being manufactured by the non-state armed groups, we collect them and we usually blast these mines so that it will not be dangerous to the civilian population as well as to the military. So there has been a procedure being facilitated here by the EOD or the experts on mines. But we
Well,
don't have
General,
any... Yes.
Let me quote from the Landmine and Cluster Munitions Monitor. This is something online. In September 2012, the Philippines reported it destroyed a further 271 Claymore mines. It has also destroyed its entire stockpile of anti-personnel mines, all Claymore mine types, in 1998. Matagal na pala. It has not retained any live mines for training purposes. The AFP has stated it has never used anti-personnel mines to combat insurgency groups within the country. So, matagal na pala to. Since 1998, you're looking at more tan 20 years, I suppose. Diba?
Yes.
So
The
in all
moment
this
we
time,
have
sir,
signed the treaty. Yeah.
in all this time, sir, not even for perimeter defense, kasi I would recognize na in some areas, in perimeter defense, kailangan mo rin ng counting, counting.
We no longer
deterrent.
employ such mines, Ed, because of the treaty that we have signed before the United Nations.
But this is both for victim-activated mines as well as for command-detonated mines, ganun ba?
Correct. But of course, our EOD experts can still employ them if there is a need, such as external defense, if there's a need.
Okay. General Naknak, maraming salamat po. That's Brigadier General Joel Alejandro Naknak, Chief of the AFP Human Rights Office. Maraming salamat, sir.
Thank you, sirs and ma'am. Magandang gabi po sa ating lahat.
Ingat po.
And that's all for this special edition of the Chiefs, but we hope what was discussed here will keep the conversation going. Before we go, a reminder to our viewers, mask on, wash hands, and stay safe, Philippines. I'm Robbie Alampay.
I'm Mami Paminto ng Philippines.
I'm Ed Lingao. We are One News.